Hello, welcome to Introduction to Law and today's lesson. For those of you who I have not had the pleasure of meeting, I'm Dr. Tracy Parker, Professor of Law and the Legal Studies Program Manager at Frederick Community College. Have you ever watched an episode of Law and Order, the crime show? All the episodes start the same. There's someone running through Central Park and they stumble upon a dead body. They call the police and the police arrive. And then just as you're hooked, the theme song kicks in. Dun, 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 dun. Boom, boom. Dun, 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 dun. And eventually, the prosecutors are involved and they take the case through the legal system. So what does the Law and Order crime show have to do with today's lesson? Just like Law and Order starts with a set of facts and then ends with the application of the law, that's what we'll do in the Week 1 assignment folders unit. You will learn about examining facts and applying law and conducting legal analysis through a process called IRAC. You will learn about the American legal system, which is the focus of what we will do now. So I'm going to share my screen. Go ahead and gather up your resources as I make the transition, and I will disable my camera, so there may be a slight delay, and I'm going to go ahead and get to our PowerPoint. You should be able to see my screen now. I'm going to go ahead and share my presentation from the beginning. Closed captioning is enabled. The American legal system is a fundamental institution in our society. And to be a successful legal professional, you have to understand how the system operates. So let's start with the question, what is law? Go ahead and think about it for a second. I like this question because intuitively we have some idea of what law is by living in a civilized society. I want you to focus on the call of the question. It's critical for legal professionals. What are you actually being asked? Here, I'm asking you, what is law? I am not asking what is the function of the law. So what comes to mind? Rules, regulations, guidelines, to name a few. Black's Law Dictionary is the leading legal dictionary, and you'll use it in your legal research, legal writing courses, and others. And I've pulled the key components from Black's dictionary as we define law. And you will see that law consists of rules and regulations established by controlling authority with legal consequences if broken. And as you think about the law and begin to look at the American legal system, it's critical that you hit all of these components. So we're going to look at rules and regulations that come from case law or court opinions, that come from statutory law, from our legislative branch, or executive orders, or regulations from administrative agencies. And if you don't follow those laws, then you suffer the legal consequences, which could include things like a monetary fine, being put in jail or prison, or even death through capital punishment. So we'll revisit this notion of law throughout our lesson today, but I want you to keep in mind you have to have these components: rules, regulations established by controlling authority, legal consequences if broken. Our next fundamental concept is to understand the relationship between ethics and law. So let's first talk about ethics generally. What comes to mind for most folks when we talk about ethics is morals and a moral compass. And I want you to be clear that each of us may vary on morality. For example, the statue of David may be a beautiful sculpture to one, and another might find it offensive. When we're talking about ethics professionally, we are looking at prescribed codes of conduct. I want you to understand that there is an intersection between ethics and law. So you may see instances where what is moral may or may not be ethical, depending on your own self-analysis, or what is ethical may or may not be legal, or vice versa. So there's a relationship. They are not one and the same, but they are connected. So just to revisit, when we're talking about ethical standards in the legal profession, I want you to be clear that there are model rules of professional conduct that are prescribed, that come from the American Bar Association, the ABA, that attorneys must follow. Paralegals are not directly mandated to follow these guidelines. However, paralegals work under the supervision of attorneys, and any work that a paralegal does is imputed onto that attorney. So vicariously, paralegals must follow the same ethical rules as the attorney, because the work that the paralegals do is then transferred to the attorney. So if the paralegal breaches a confidence, it is just as if the attorney did. There are professional paralegal associations that you will also learn about in this unit that have created voluntary codes of conduct that mimic the attorney's professional standards in many regards, that paralegals can agree to abide by. So in the industry, paralegals are seeking regulation as it pertains to ethical standards, the prescribed code of conduct. But to date, there are no nationwide governmental requirements to be a paralegal or that regulate the paralegal industry. And that's a topic for later discussion as well. So the takeaway from this material is there is a relationship between ethics and law, but they're not one and the same, and that there are professional standards that you must follow as a legal professional, whether you are an aspiring attorney or an aspiring paralegal. It follows then that in our program, we have a professional responsibility and ethics agreement. You will be assigned to read that agreement, sign it, and upload it into Blackboard. If you have any questions, please reach out to me. What we're trying to do here is to maintain a sense of integrity in our program, and start students out early on with recognizing the importance of professionalism and ethics. You will have many opportunities to work with clients, legal stakeholders, and the like, and we need to do everything we can to ensure that all are on the same page in terms of professional and ethical expectations. There is an entire course on ethics in your program, and ethics is infused as well as professionalism throughout the entire program. Why is it important for the law to evolve? Or another way to frame this question is, why is it important for the law to be flexible? The answer is society's moral compass changes, so the law needs to change to reflect the new norms of society. Technology changes, so the law needs to meet the advances in technology. And there are times when law leads society. So let's look at a few examples to put this question of why does the law evolve, or why is it important for the law to evolve, into perspective. We're going to begin with an 1896 Supreme Court case, Plessy versus Ferguson. Some of you may be familiar with the Plessy decision, but let's go back to some facts. So back in the late 1800s, there was a Louisiana statute that required, to use the language of the statute, coloreds and Caucasians to ride in separate railway accommodations. So they couldn't sit in the same section of the railway. Now I want to take a sidebar here and highlight that your Introduction to Law course meets the cultural competence requirement for those who are seeking a degree in paralegal studies. In fact, all degree programs at the college have a cultural competence requirement. And so it's important for me to share here that while we are using the language of the court, and you'll find that the courts reflect the norms of the time, and so do statutes, the language that is used at particular points in time in our history, but it is not appropriate to refer to African Americans as coloreds, but that is the language of the court in this case. So back in Louisiana, African Americans or coloreds could not ride in the same railway accommodations as white folks. And what's interesting about this particular scenario is, much like the collaborations, civil disobedience that you see today, or in, during the civil rights movement, there were organizations and folks were organizing to challenge what they considered to be unjust laws. So Homer Plessy actually worked with the Citizens Committee of New Orleans to join together to purposely violate the Louisiana statute. So he was set up to get on the railway, get on the wrong seat. They actually informed law enforcement that he was going to be there so that he could get arrested, and that would get him in the system. And this case eventually made its way to the Supreme Court. Now take a look on your slide, and there's an image of Plessy, and you'll notice that he could pass for white. His heritage was known, and he was actually a multicultural man. And the Supreme Court back in 1896 identified him as having 1/8 colored blood. So they applied what many of you may know as the one drop rule. You may have heard of it as, if a person has 1 drop of black blood, then that means they're black. That's essentially what occurred here. And because of that, the Supreme Court found that he did, in fact, violate the Louisiana statute, and separate accommodations were equal. So out of the 1896 case, you get the separate but equal doctrine. Now let's fast forward to 1954 with Brown versus Board of Education, which is another Supreme Court landmark decision. And this was a case that involved school segregation, and the result actually led to the integration of schools, and that's why all of us can actually learn together. With the Brown versus Board of Education case, you essentially had African American children having to bypass schools that were close to where they lived to go to a lesser quality segregated schools. They did not have the same resources. And so you had a group of folks who filed a lawsuit, and this case was actually heard by the Supreme Court. And the Supreme Court held that the separate accommodations were not equal. And in so doing, they overturned the Plessy decision, which had originally held that separate was equal. So what you see here is an evolution of the law. You started in 1896 with separate was equal, and you end in 1954 with separate is not equal, and you get integration. So my question to you is, was our society ready in 1954 to integrate? I would say definitively no. While you will find pockets and locations where people were coming together as one race, you actually had the National Guard being brought out to prohibit school-aged children from entering the schoolhouse. Take a look at George Wallace. Google George Wallace and the National Guard and school integration. So here's an example of where the law evolved and it led society. A couple more examples. In 2015, we have marriage equality ruling, which the Supreme Court in a 5-4 decision ruled in favor of same-sex marriage and identified it as a right. And so now in the United States, we have marriage, period. We don't delineate. Let's move now to how the law is classified. And what you see here on your screen are three classifications. So we can look at law and break it down, into three separate ways. The first category would be to determine whether a law is substantive or is it procedural. Secondly, you look to see, is a law coming from your federal government or is it coming out of a state? And thirdly, you determine whether law is in the criminal system or the civil system. So let me first just quickly address the federal versus state distinction. If you will, think about a map of the United States. If you have laws that apply to the entire country, those are federal laws, as opposed to an individual state like Maryland, and you have law coming out of Maryland, out of our legislative branch or out of the Maryland courts, that would be a state law. We can use taxes as an example. We pay federal taxes, and there are a set of laws that regulate deductions, what's owed, and so forth. And those are federal laws, and we all pay federal taxes. And then you go to the individual states, and you also have to pay or you receive a refund based on the state tax laws. So tax law can be both federal and state. That would be an example of the distinctions. Let's look at the difference between substantive law and procedural law. You'll need to know definitions and the distinctions for your exam. Substantive law is law that creates and defines duties, rights, and obligations. So, for example, I like to think of topics of law in this area. So substantive law includes contracts, torts, real estate, estates and probate, family law, contract law. So if there is a law that states how a contract is formed for the sale and purchase of a car, the substantive area of law is contracts. Procedural law, on the other hand, is law that describes the manner in which the substantive law may be enforced. So here you're looking at the process. So for example, procedural law would be the law that states how a lawsuit would be found if there was a breach of contract for non-payment. So what are the requirements to file a complaint? How many days does the defendant have to respond? It's the procedural law. On your exam, you'll have to match these definitions. So just become familiar with it for now. Next, we're going to look at the distinction between criminal and civil systems. There is a comparison chart posted in the week 1 folder. So it will be helpful for you to go through this chart. You will have to put that information into a chart on your exam. And we're going to use the O.J. Simpson cases as our case study to learn this material. So we're looking at, with the O.J. cases, 2 cases that made their way through the court system. One went through criminal. That was the criminal case was first, and the second was a civil case. I want to take an opportunity here to give you a very quick overview of the phases of a trial. And this is only a portion of the litigation process. But just so you have this and know that this would be connected to your civil procedure class, the phases of and you will not be tested on this material. Phases of a trial include jury selection. So a jury has to get picked. Those who are eligible for a jury typically are selected or identified through voter registration or maintaining a license. So just think for a minute the importance of that, because we should have a jury of our peers. Juries are selected through a process called voir dire. Once the jury is selected and impaneled and sworn in, the proceedings begin. There are opening statements by both the plaintiffs, if it's a civil case, or the prosecutors, if it's a criminal case, and then the defense puts on their opening statements. Following that, you have the plaintiffs or the prosecutor's case presented. So it is the plaintiff or the prosecutor, those that are bringing the lawsuit, go first. They put forth their evidence. Once their case is closed, once they rest, the defendants put on their case. And note, there could be motions made in this process, but once the defense rests, you'll hear closing arguments. And then the jury is provided instructions. And in those instructions, they are given the law, and they're essentially asked to perform legal analysis. So I'd like to connect this to the IRAC process. It's where they go through issue, rule, analysis, and conclusion, and their deliberations. At least that's what they should be doing. Now keep in mind, your jurors are not trained legal professionals, so they're asked to perform legal analysis without real training on how to do so. They have their deliberations, and then they reach a judgment. So that's the process in a nutshell. Let's take a closer look at the O.J. Simpson scenario. So let's continue with, let's continue with a review of the evidence that was presented at trial. And again, we're going to get to an application of the distinctions between civil and criminal, but we need facts and information. We need the story in order to do that. So in that criminal case, the prosecutor put forth evidence. And when they presented their case, here's what they had or didn't have. There's no murder weapon, no witness to the murder. There were 2 bodies, nearly decapitated, Nicole Brown and Ron Goldman. There was a trail of blood evidence. There were bloody shoes, footprints, socks. There was a bloody glove that tested positive with Goldman's blood. Timeline based on testimony from the limousine driver and Kato Kalin made it possible that OJ could have committed the crimes. There was a 911 call, which evidenced that Nicole was a battered wife. So this is some of the what it was referred to as the mountain of evidence presented by the prosecution. The defense had evidence as well when they put forth their case. They were able to demonstrate that there was the mishandling of blood evidence. An officer kept blood evidence from the scene in his pocket and carried it to OJ's house. They were able to show an error in the crime lab. The lead detective, Mark Furman, was shown to be a racist, and he actually perjured himself on the stand when asked about racist remarks. They were actually able to show instances where he did an interview and used racial slurs and talked about planting evidence in other cases to frame not only Black people, but gays and Jewish people as well. And he was responsible for collecting the socks, the shoes, and the glove. There was a glove found at the crime scene, and there was a demonstration where OJ actually put on the glove and it didn't fit. And in closing arguments, the attorney, Johnny Cochran, actually argued, if it doesn't fit, you must acquit. So based on this evidence in the criminal case, the O.J. Simpson jury came back with a not guilty result. Let's move on to the civil case. In the civil case, the families, so Ron Goldman's family brought a civil case. And let me just take a sidebar here and give you information. When you go to civil, you're in another court system. So the concept you may be familiar with or heard of double jeopardy does not apply here. Double jeopardy is a legal concept that prohibits being tried for the same crime twice. In the civil case, and when you're in civil court, the laws are not criminal. So you're not using a substantive area of criminal law. Instead, you're going to use tort, and this is a wrongful death lawsuit. So the families brought a wrongful death lawsuit against OJ. There's a different standard. The burden of proof is preponderance of the evidence, whereas in the criminal case, it's beyond a reasonable doubt. And using this different standard, the jury found that Simpson was guilty. And so it's important to note, in the criminal case, he was facing the death penalty. In the civil case, he was facing monetary damages. So he did lose in the civil case. He was found liable. And what the family was awarded damages, which means money. So my question to you is, were the cases correctly decided as a matter of law? Go to the discussion board in Blackboard to have a conversation on this issue. Take the next few days, post your comments, and then I'll chime in and we'll sort out whether these cases were correctly decided as a matter of law. And keep in mind, you're being asked to focus on the call of the question. So we look at our overview of the American legal system. It's important for us to continue to think about our definition of law. What is law? Law is rules and regulations that come from controlling authority, and there are legal consequences if broken. This section of our material focuses on that controlling authority. Where does law come from? What are your sources of law? We have several. We're going to take a look at some to get you started here. So the Constitution, which is the law of the land, is a source of law. There are a couple of things I'd like you to note about the Constitution. We have the United States Constitution, which applies to the entire country. So it is a federal law, as we've already discussed. There is a concept known as federalism, which means our federal government and the states and our territories share power. And the United States Constitution outlines how that structure works. The United States Constitution is our branches of government. There are three. You have the executive branch, the legislative branch, and the judicial branch. And I'll provide material in your week 1 assignment folder to give you some more information. But for now, I'd like you to know that the Constitution outlines the branches of government, and we'll be looking at the powers of each branch. Quickly, the legislative branch creates law, the executive branch enforces law, the judiciary branch interprets law. The Constitution also gives us our checks and balances system so that no one branch has all the power. And we also keep our branches of government separate. And this together, so our checks and balances and the separation of powers, promotes our democracy. Another source of law is case law. This is where your law that comes out of your court system, out of the judiciary branch. There are a few concepts that you should be familiar with. There's the term or the phrase common law. Our system is derived from the English common law system that follows case law and precedent. So if you have a case, it sets authority for cases to come on the same issue. Precedent means previously decided cases. And we also follow a doctrine called stare decisis, which means adhering to or following, standing by the decision. So if you think back to our conversation about Plessy versus Ferguson and Brown versus Board of Education, you have an example of precedent being established in 1896 when the separate but equal doctrine was created, and we followed the doctrine of stare decisis and adhered to and by that decision until 1954, when it was overturned with the Brown versus Board of Education decision. So that's an example of adhering to the doctrine of stare decisis and following precedent. But your case law comes out of your judiciary branch. Statutes come from the legislative branch of government. This is where you have law that gets codified through presentation in a bill. It gets voted on and eventually becomes a statute. So you get law from your legislative branch. And I want you to keep in mind as we're going through this, we have the federal Constitution, or United States Constitution, where it applies to the country, and then each state has its own constitution, so that mirrors the United States Constitution, so that each state has its branches of government. So when we're looking at cases and statutes, I want you to know that each individual state has their own judiciary and their own legislative branch. So you get law both on a federal and state level. So you have statutes is another area of law, again, out of the legislative branch. And then you have, we call it administrative regulations. I want you to know that the framers of the Constitution had the foresight to recognize that those in the legislative branch, Congress, would not be all-knowing. And so they created the ability for administrative agencies to be established. So you could have, if you will, specialty areas. So you get the Department of Education, for example, or the Motor Vehicle Administration, or FEMA, or the Food and Drug Administration, to name a few. And those agencies create law. They have regulation. They also have oversight and enforcement ability, and there are consequences if those regulations are broken. I'd also like you to note that legal professionals, paralegals, and attorneys alike can find employment with administrative agencies. And as we wrap up, I would like you to have an idea of our court structure. We have a 3-tier system. And this, again, will be material that you'll learn in your civil litigation class. It's now LGST100. An error in my slide here. But so we have a 3-tier system. We appeal upwards. So we have our trial courts at our lower level. We have our mid-level review courts, which is an appellate court. And then you have your highest court. And in additional information in your week 1 unit, I will give you an outline or resources to give you the actual names of the courts in our federal system. And then we'll also look at our state court, Maryland, and have the names of those courts. So I want you to have that material where you can actually see it written down. But for now, I want you to understand the structure. And then you'll get the material that'll show at the federal level, for example, it's United States district courts at the lower level, and then you put that arrow and appeal up to the United States Courts of Appeal, put the arrow and you appeal up to the United States Supreme Court. And then in our federal system, we also have specialized courts, and examples would be bankruptcy court. So this is where we will end this presentation. I'm going to stop screen sharing. And I am back. I hope everything worked. If not, I will give it another shot. I enjoyed our time. If you have any questions, I am reached most readily by email, tparker@frederick.edu. Send me an email, work through the material in the assignment folder. I look forward to your discussion board conversations. And again, if you have any questions, please reach out quickly because this is a fast-paced semester.